You find out the debtor has that is exigible, that's property that you can seize that's not exempt under the laws of the province, then you can have the sheriff seize it. And when I say that, it's simple as that. Simple as directing the sheriff, writing him a letter saying he has a bank account at the Toronto-Dominion Bank at Queen and Bay, please seize his bank account. And the sheriff will report back to you whether he did or he didn't and how much was there. A judgment debtor examination is usually the information that I think that a creditor, and in a creditor-debtor context, not in a plaintiff-defendant context, should have before he advances credit. In other words, if he's going to advance someone credit, he should know everything about him before he starts. Well, unfortunately, that's not the way it works in practice, except for major banks and major loans. They find out all this information after, and that's what the judgment debtor examination is about. Page 94, general information. People move. They move within the city, outside the city, towns, out of province. The more information you know about the background of a debtor, the better off you are. And this is the information that you request from the debtor. If he doesn't cooperate, of course, we've got that committal scenario, and eventually you will get all the information. This gives you tracing power because, remember, your judgment's good for a long time as long as you keep that writ of execution going. And if your debtor doesn't go bankrupt, if he doesn't do it to himself, the chances are you're going to get paid. You may have to wait a number of years, but you will get paid. And you need, especially, the first general information, the first category, is extremely important. Employment. You have to know what type of job that he has, what type of job that he had in the past. You have to know where he's going to move and how he's going to move. And you know that by his background, his education, his prior employment record. This will give you an idea of where he's going. If he's unemployed, find out why, where, his salary or wage, whether or not he's collecting unemployment insurance, and other source of income. Usually you can have family members helping out while he's unemployed. Wife's employment or spouse's employment, that's important. I think some of you have probably experienced very wealthy judgment debtors. They live well, and you wonder where they're getting the money. They live in these high-rise condominiums, and they drive expensive cars, and they dress very well, and they go to the restaurants. And yet he's a debtor, and they say, where do they get the money? Well, sometimes it's family, sometimes it's hidden, sometimes it's a spouse. So it's good to know things about the other spouse, and that's what 4 is about. Same for residence and leasehold. This is basic information that we all assume, we all take for granted, and yet it's very important we find out this information so that you know where an asset is. The realty on page 96. This is a situation where you want to put yourself in a position, if you're conducting a judgment debtor examination, of being a realtor. And if you're a realtor, you want to know what type of house it is. If you find that information out, then you'll have it down nice and neatly, and when you go to sell the house or instruct the sheriff to sell the house, you'll have it all there, because that's the information you need to sell the house. So you might as well get it ahead of time. Vehicles. Cars, trucks, tractors, airplanes, motorcycles, motorboats, or have the use of such. You'll often find that the debtor drives a very expensive automobile, but he doesn't own it. His wife doesn't own it. His cousin doesn't own it. It's his next-door neighbor's. And you say to yourself, is that possible? Is the next-door neighbor going to lend you an expensive automobile every day, 5 days a week? No. There's something wrong. And that's where a good examination will bring that out. Insurance. Insurance is effectively not attachable. However, there are certain cases where you can seize insurance, and insurance questions should be asked. Bank accounts. Bank accounts can be seized. The difficult problem that still plagues our courts, and there's not clear law on it, is where you have a bank account in the name of A and B. And A is your debtor. The question is it's also B's account. And to what extent is it B's account? So you have a tracing problem, who owns what in that joint bank account. If I'm acting for a creditor, I'll say, seize that account, we'll talk about it later. Stocks and bonds. Same thing, stocks and bonds. Some people do not have the physical stocks. They have them with their broker. And one of the questions is you ask, where are the stocks and bonds? Who's got them? RSPs. That's very popular today. They can be seized. They can be seized. The sheriff can be directed to attach your RSPs at any of the chartered banks or trust companies or insurance companies. Personal property and household furnishings. That's a scary area, because when you have a debtor, you wonder how far you can go into his house to seize the new coat, the ring, the jewelry, the television set. Effectively, there are exemption laws under the Execution Act covering household goods and furnishings. The numbers aren't very high, $2,000 for household furnishings, $1,000 for apparel, but the mean creditor, or the creditor who really wants to get paid, he says, here, debtor, here is your $3,000, and he cleans out the house. It doesn't happen very often, but it's done. And that's one way of making sure that you can get paid. Other creditors. Last category, it's important to know other creditors. Why? Because if all the creditors are starting to move in on them at once, then it's game over pretty soon. But if there's only a few around, well, maybe you can get together to work out something with the debtor. That's very important. I think my time is up. Thank you for being attentive. Whoop.
Walk away with it.
Don't walk away.
Law
Everybody's,
Society won't
that's
let
right.
you.
Sure.
Thank you, Mr. Bennett, and thank you for taking us through the procedures of attempting to collect from our defendants who become judgment debtors. Next on the program, we have powers of sale, and we have as our speaker this morning Carol MacPherson. Carol was called to the bar in 1979. She started her career in Streetsville, and then 2 years ago, the bright lights of Toronto beckoned her to join Staples and Sewell. Carol's practice is largely in collections, and she has found time to co-chair and participate in programs for the Law Society on mortgage remedies. Carol MacPherson.
Thank you, Adeline. Two questions occurred to me in talking about power of sale. I don't know how many of you really know what a power of sale is. I'm going to attempt to answer that question. I'm also going to attempt to answer the question of what do I do next? I often get phone calls from people, from lawyers, from mortgagors, from secretaries, saying, what does this mean? What is the next stage that has to take place in effecting a power of sale? The materials that you have before you go through the stages right from receiving instructions from the client to the point of selling the property. You don't always get that far. Sometimes the mortgagor comes up with the money and everything comes to a halt. What a power of sale is a number of procedures for a mortgagee, which is the people lending the money, the bank or the trust company, to try to collect on a mortgage debt. Mr. Bennett spoke to you about collections in general. This is a very specialized type of collection. Being a private remedy and not particularly supervised by the courts, it's very incumbent on the solicitor and his or her staff to be very careful about every stage of the proceedings. The possibilities of making errors are all over the place in just about every procedure. And the consequences of making an error are very serious. You can make an error right at the beginning when you send out your notice of sale, and it isn't caught till the very last moment. It can be that the notice of sale that you've sent out is totally invalid and you've got to start all over again. That can be the worst thing that can happen. I'll detail a few of the horrible errors that can be made later on. The procedures usually commence with receiving instructions from your client I'm assuming here that we're dealing with institutional lenders, in other words, banks or trust companies or insurance companies, and not with private mortgagees. The mortgagee usually has a mortgage department that will have already sent out letters to the mortgagor with respect to the mortgage arrears. Sometimes months go by before the file really hits your office because there's been negotiations or attempts to settle the matter. Once the file gets to the solicitor's office, it's usually, that there's been attempts at negotiations and nothing's come of it, and it's a matter of really getting on with it at that point. The mortgagee isn't interested in having any more delays in trying to collect the mortgage arrears. The first stage that happens is that a demand letter is usually sent out. There's a precedent of a demand letter that we have used in our office in the precedent section. I believe it's at page 122. As with any precedents, this is just the form of letter that we have used. There can be variations naturally. The demand letter will set out the amount of the arrears. It is sent to the mortgagor at the address which the mortgagee has provided to you. That's really important to make sure that you've got the right address, because often the mortgagees will have been sending letters, getting no response, and the reason is because the mortgagor doesn't live there anymore. To put it bluntly, the mortgagor usually does owe the money. There's very few cases where it isn't, there isn't a reason for not being able to pay the mortgage. But to send out a demand letter, we've given usually 10 days, sometimes 15 days to the mortgagor, puts them on notice that it's now in the hands of a solicitor, and if something doesn't happen soon, we're going to go on and get to the stage of basically taking a house away from the person. With a demand letter, as I said, usually we give them 10 days, or sometimes 15. It's important to set up a tickler system so that once that demand letter has expired, the file will come back to the attention of the lawyer. Once that expiry date has passed and there's been no response from the mortgagor, the next step is to do searches. The searches are necessary to start the notice of sale proceedings. The search that takes place is in the registry office or the land titles office where the property is located that the mortgage is on. The search is really, it's not a full search of the title by any means. We call it a sub-search. You basically find out all the subsequent mortgages that are on after your client's mortgage, and you verify the names of the parties that are to be served with the notice of sale. The Mortgages Act, which is the act which governs the procedure with notice of sale, provides that to be effective in the mortgagee taking back the property, all parties which are subsequent to your client's mortgage must be served with the notice of sale. It's very specific in saying that. It indicates that the search of title must be done on, well, the parties that must be served must be those appearing no later than 4:30 of the day before you send out the notice of sale. Since you really can't do a search right at 4:30, our practice is to do the search on the day the notice of sale goes out. Since it usually takes a few days to prepare a notice of sale, in general, we do a preliminary sub-search, prepare the notice of sale, and then update the search on the day the notice goes out. The Mortgages Act specifies the manner of giving notice to the relevant parties. Most mortgages provide that service can be by registered mail. And the Mortgages Act confirms that. There are some mortgages, I've seen a couple, but not very many, that specify that service has to be personal service. There's also other provisions that you could leave the notice at the property, or you can, or it could be personal service only. But in general, that would be a very, very unusual situation. That kind of area would be something that a solicitor would have to make sure that there's nothing unusual about that mortgage. The kinds of parties that you'd be serving would be subsequent mortgages, in other words, a second mortgage or a third mortgage. They can also be, for example, mechanics liens claimants against the property. In that case, you can serve the solicitor which filed the mechanics lien claim. The other type of search that you do is the search of executions. I think you've heard enough today to know what that is. You go to the sheriff's office or the land titles office and search against the names of the owners to make sure there's no execution creditors. Again, with execution creditors, you can serve the solicitor who filed the execution claim. But you can't serve collection agencies. It's only solicitors that you can serve. Okay, so you've got your notice of sale search done, and we've got, I think, again, a precedent on page 124. That's based on the standard Dye and Durham form, which sets out the information which is necessary to be provided in the notice of sale. It says it's all persons named in Schedule A. Those are the parties that I've been referring to. You have to indicate the details of the mortgage under which you're taking these proceedings. And you have to indicate what the arrears are, what the full amount of the mortgage is now due. And any other costs that you have paid, for example, taxes or insurance premiums, plus your legal costs. Then it goes on to indicate that there's a certain amount of time for which the mortgagor or subsequent parties, that they have the option too of bringing the mortgage into good standing, have in which to respond to the notice. Now, the Mortgages Act says that it shall be at least, and you now know what that means, at least 35 days after the notice has been given. There's been some case law on the fact that because of the Family Law Reform Act, which I'm sure some of you are familiar with, there's a provision in the Family Law Reform Act which indicates all spouses of registered owners of property have the right to receive the same kind of notice, even if though they're not the registered owner. And it says that such notices to spouses are deemed to be received 5 days after mailing. So there has been judicial decisions saying you have to add 5 days onto your 35 days. There's also case law that says you don't. So in that case, it's a decision for the solicitor. Our office has taken the position that 35 clear days, i.e. 37 days, is correct, but that's something that would have to be decided. Okay, we've got our notice of sale already prepared. In general, it's going to go out by registered mail. There's an example of a post office registration receipt on page 126. You set out all the names of the parties that you've served, and you prepare the receipt in duplicate, get all your letters together with registered mail on them, you can take them down to the post office and get back the original post office receipt. The post office keeps the other one. You have to have that original receipt because if you get to the point of selling the property, you're going to have to register some papers that show what you did to get to the point of selling the property. The Land Titles Office always requires an original post office receipt. Adeline was asking me the other day whether it was my experience that registry offices always need them. I believe they do. Registry offices, as opposed to Land Titles Office, sometimes vary in their procedures from county to county. But it's to be on the safe side, the original post office receipt should always be retained, and that should be kept very securely in the file. That's one document that you don't want to lose. So once you've decided on your time limit for the notice of sale, again, a tickler system should be set up. This is assuming that we're still not getting any response from the mortgagor whatsoever. So the time limit goes by, and the file again is brought up to the attention of the solicitor. At this point, the mortgagee basically has the right to sell the property, but the mortgagor is maybe still living on the property, ignoring the notices, ignoring the letters for whatever reason, but you've got to get possession of the property in order to be able to sell it to someone else. This is where we get into the court part of doing a power of sale proceedings. In most cases, you're going to have to issue a writ of summons, a specially endorsed writ of summons, in the Supreme Court of Ontario, asking for possession of the property and also asking for payment. The payment provision is that sometimes the property is not going to be sold for the amount of your client's mortgage. It may be that the property has somehow decreased in value. There are so substantial arrears on the mortgage that the mortgage debt is far more than the property is worth. In that case, you have the right, or the mortgagee has the right, once the property is sold, to make a claim against the mortgagor for that deficiency. So the writ of summons can claim both possession and payment. The writ of summons is issued out of the Supreme Court of Ontario. You have to serve the mortgagors. If you happen to know that there's anyone else living on the property who's not a mortgagor, for most cases would be a tenant, you should put that person in as well as a defendant. Then you have to get the writ served. Hopefully in most cases the people are living there. It's not too difficult to get them, but if you're familiar with litigation, you know that defendants try to evade service, and you may have to get a subservice order. After the time limit for which the mortgagor has to put in an affidavit of merits has expired, you're in a position to go and sign judgment. You've been told this morning, and I'm sure most of you are aware, how to sign judgment and prepare your bill of costs. In this case, you also prepare an affidavit of change of account. I believe that is on page 137 for an example. The judgment is signed before the Deputy Local Registrar in Toronto, and the Deputy Local Registrar wants an affidavit by the mortgagee stating what is now owing on the mortgage, which may be not completely different, but it may be substantially more than it was when the writ was issued if you've had problems serving the people. So you attend before the registrar with those three documents, your draft judgment, draft bill of costs, and affidavit of change of account. You get judgment signed in the normal manner, get it entered and ordered and signed, and then you're in a position to get a writ of possession. This is the document that you're going to send to the sheriff, who will then go out and basically evict the people on the property. But it's not quite that simple. There's an intermediary step between getting your judgment and getting the writ of possession. You have to make an application under the rules of practice, Rule 567, to get leave to issue the writ of possession. Now, the reason you have to do that is that, as I indicated earlier, there may be people living on the property who are not the mortgagors and have no idea that any of this is going on. They've been paying their rent to the mortgagor, and the mortgagor has been doing something else with the money instead of paying the mortgage. So the Rule 567, an example of which is at page 143. The rule provides that all the people who are in actual occupation of the property must get notice of the proceedings before you're allowed to get the writ of possession. So this is a matter of having to find out who's really there. Often your sheriff or your process server that has served the writ of summons on the people will come back with some sort of an affidavit saying, actually there's someone else living there by the name of so-and-so. You'll have to make in your affidavit that there is another person living there who's not a mortgagor. Sometimes it's not that simple. You have to, what we've done is phone the property address and just ask who's living there, who's over the age of 18, because there may be children over the age of 18, there may be grandparents, there may be tenants, whatever. Your affidavit sets out that you made an inquiry on a certain day, or that someone else made an inquiry, and that these are the people who are in actual occupation and so have received some sort of notice because you send a notice to them telling them what's happening. You send out, it's on the other side of the page, the notice demanding possession, which indicates that judgment has been obtained for possession, gives you a certain amount of time to vacate the premises, and basically if they haven't got out by that point, you're in a position to make your application using your affidavit. The application under Rule 567 is made in Toronto before the master and out of Toronto before the local master. You attend with your affidavit and your draft order for leave to issue the writ of possession. Then you are in a position to get the writ of possession. In Toronto, we usually recommend that you prepare it yourself because the typist's office often takes about 2 weeks to get it. And at this point, your client is probably jumping up and down saying, this mortgage hasn't been paid for a year, we've got to do something about this. So once you've got your writ of possession, you can send it to the sheriff, and the sheriff in each particular judicial district or county have different procedures about what they actually do, but that's up to the sheriff. I believe in Toronto, for example, they give either a week or 10 days, and for the people to get out of the property, and at that point, the sheriff has to go out and physically evict the people that are there. In almost all cases, the people have gone voluntarily before that point. They finally realize that the mortgagee is serious about doing something about this. Okay, then we get to the point of being able to sell the property. The mortgagee has obtained possession of the property. In most cases, the mortgagee will get an appraisal done of the property, and that's something that usually the law office doesn't get involved in. If it's a large trust company, they usually have a real estate arm of the trust company, and they handle getting the appraisals and the listings. The major thing that is left to do by the law office is preparing the documents for registration. As you know, there are two different systems of land registration in Ontario, registry and land titles. The requirements are fairly similar, they're just called different things. There's a draft deed at page 145, and draft deposit of sale papers at 146. The information which is set out is basically saying that there was a mortgage, default occurred, nothing happened, and other than a notice of sale went out and nothing occurred in response to it, and now we're in a position to sell it to a purchaser. In land titles, they're just called different things. They're called statutory declarations. And the major difference in land titles and registry is that land titles must what's called pre-approve the sale papers. This is something you've got to keep in mind when you've got an imminent sale and all of a sudden you realize that the property is in land titles. Land titles will not accept the actual document for registration until they've had a chance to look at it and make sure that you've done everything right. They'll go through and check the parties, check the dates of the mortgage, and check the number of days you've given, and they'll let you know if you've done something wrong. So you can't find that out the day before you're going to, try to sell the property. I haven't gone into, in the materials, the very final stage, which is accounting for the proceeds which you've received on the sale. That doesn't happen very often, that there are excess funds left over. But if there are, you're obliged to account to anyone else who had an interest in the property after yours to tell them what's happened with the rest of the money. Your client is only allowed to get back what they've put into it. They can't take all the money. They only get what's amount owing on their mortgage and costs. So if there is any money left, it will have to go to the people coming after you in their order of their priority. Okay, that's what happens from start to finish very, very quickly. It's a fairly long, involved, and complicated procedure. There's a couple of areas I'd just like to emphasize where there are possibilities for errors. I think I've alluded to some of them. Errors in the notice of sale. If you've forgotten to serve somebody because your title searcher missed something or you missed something, that can be a problem in that you will not effectively have dealt with the interest of a party that you haven't served. That interest, like if you've got a first mortgage and there's a second mortgage on there that you forgot to serve, that second mortgage is not cut out by your power of sale. So it's absolutely essential that you get all the parties that have an interest and make sure you've got all their names right to go on that Schedule A to the notice of sale. Secondly, errors in description. Again, it could be your problem that you misread your title searcher's instructions or you missed a line on the description. It's not necessary to do a full meets and bounds description, which is all around the property. You just have to put the lot and plan number. But I've had occasion in my office where there have been errors made, and while some of them can be fixed, there's always a way out of things, but some of them are really serious, and it means the whole notice of sale is no good. You've got to start all over again. The other thing which is important is to do everything on a timely basis. As I've indicated, by the time the file gets to your office, the mortgagee is really concerned about getting the thing settled. There's interest running on that mortgage from the time it went into default until they're finally paid off. And they'll be really interested in making sure everything is done on a timely basis. Once your demand letter expires, your notice of sale goes out. Once that expires, your writ of summons for possession is issued. It's very prejudicial to the client if basically that the file is not dealt with on a timely basis because they're not going to be interested in your excuses for why things weren't handled. Finally, there are problems when I've been going along on the assumption that there has been no response by the mortgagors for whatever reason. Either they've abandoned the property completely or they're just trying to ignore it and hope it'll go away. But, and this is something that legal secretaries and legal clerks should keep in mind, sometimes people in this situation do contact your office and talk to you. They're in a very difficult situation, mortgagors, and in this time they are basically losing their home, and people can become really abusive on the telephone. They can also try to manipulate someone who they feel perhaps doesn't know about the file. I've had experiences where mortgagors come in and plop money down on my secretary's desk and say, there, that's it, that's all I'm paying. It's very important in that situation to make sure that you always have instructions from the solicitor and from your client into what is going to happen in that situation. I think that's all I have to say about power of sale. Thank you.
Thank you, Carol. And in view of the economy today, I'm sure more of us will be working on powers of sale, and I'm sure that the comments made by Carol and the documents that she has provided you with will be of great assistance. Last but not least in our program is family law reform, and we have with us this morning Ruth Mesbur to speak to you on that subject. Ruth hails from Regina originally. She was called to the bar in 1974. Her practice is in family law. She also lectures for the bar admission and has participated in programs in family law for the Ontario section of the Canadian Bar Association and the Law Society. Ruth Mesbur, please.
Thank you and good morning. I've got 15 minutes to tell you all how to manage a family law case from beginning to end, so I'll talk fast and try to cover as much as we possibly can. You'll find the materials on division of property and support and maintenance starting at page 159 of the materials. First, to start with division of property or property claims generally, because I think they're somewhat more complex. They are governed by sections 4, 7, and 8 of the Family Law Reform Act, which many of you will recall came in 1978 and really revolutionized the law of property in Ontario. Essentially, there are three kinds of property claims that a spouse can make. The first is for division of property. The second is for compensation for contributions which were made to property, either directly or indirectly, either by money or by working or contributing to the family in a general way. And finally, there's a claim for possession of property, the right to actually occupy the property. Section 4 is probably the most important section of the Act. It deals with the concept of division of family assets. And what it is it's a division based on the use of the property. Assets which are generally used for family purposes, houses, cars, boats, things of that nature, are what we call family assets. And married people have the right to have their family assets divided 50-50 if they are living separate and apart at the time of the application and there is no reasonable prospect of their resuming cohabitation. Family assets are generally 50-50, although there are circumstances in which family assets can be divided unequally. If there's inequity involved in a simple 50-50 division, the court has the power to make an unequal division of family assets, and in fact can go on and make a division of other assets, which by definition are non-family assets, again, if there is inequity involved in simply limiting a spouse to a claim to family assets. Sections 7 and 8 of the Act deal essentially with compensation for contributions made to property, either directly or indirectly. That's essentially what Mrs. Leatherdale went to the Supreme Court of Canada on. You probably all read about her case in the paper, making a claim to her husband's Bell Canada shares. Those are the kinds of property claims that you are going to be seeing most often in the office. Now, what's unusual about family law is that we have many courts with concurrent jurisdiction, so that depending on where your bosses practice, they may be choosing to proceed in the county court, they may be choosing to proceed in the Supreme Court, or if the parties both reside in the Judicial District of Hamilton-Wentworth, they must proceed in the Unified Family Court in Hamilton. Now, a word about the Unified Family Court. You will not find any precedents for the Unified Family Court in the materials. They have their own forms, their own procedures, and if you're faced with dealing in the Unified Family Court for the first time, I would suggest that you contact the court office there. They're tremendously helpful in helping out-of-town solicitors deal with their procedures, and contact a lawyer in Hamilton to tell you what to do, because it's totally unlike any other court in the province. Now, in the Judicial District of York, we rarely use the county court for any applications dealing with division of property, so that the precedents that you will find in the materials deal with an application in the Supreme Court of Ontario. But you could as easily simply change the style of cause to the county court of your judicial district, and the precedents will work just as well. Now, the other thing that's unusual, you have this choice of court for division of property. You also have a very broad choice of how you can commence your application. It isn't a simple case of, well, you just issue a writ and that's it. One of the most popular ways of commencing an application for division of property, a simple, straightforward application, say for only an equal division of family assets, will often be made in the Supreme Court by way of an originating notice of motion and supporting affidavit. And you'll find a precedent for this on page 168 of the materials. And you'll see in the style of cause that it's styled in the Supreme Court of Ontario Family Law Division. Now, the Family Law Division is a special division of the Supreme Court where family law matters in Toronto must be brought. So that if you're in Toronto in the Supreme Court with an originating notice, you must style it Family Law Division. And you can see in the body of the notice of motion that what the party is asking for is, first of all, a declaration that certain real property is, and the contents of the property are family assets. That's in paragraph 1. And the second paragraph is asking that those family assets be divided equally between the parties. So you're dealing with a very, very straightforward application here that's simply asking for equal division of family assets. Over the page on page 170 is the basic affidavit that's required. The party deposes that he and the respondent are married. That's a condition precedent to the application being brought. He states that they are separated and there's no reasonable prospect of their resuming cohabitation. Again, that's got to be in the affidavit material or the court is without jurisdiction. The parties must be separated. And finally, he talks about there being joint owners of the property and then goes on to state the use of the property. Now, it's the use of the property that tells you whether it's going to be a family asset or not a family asset. If it's used as a family residence and used for family purposes, regardless of who holds title, the property is a family asset and the spouses are entitled to an equal division of it. So that's the very, very straightforward, simple application. Now, with any application for division of property, whether it's family assets or non-family assets, the parties must file a statement of property under the rules. And this you'll find on page 171, the following page. Now, the forms are very precise, and you've got to follow the form exactly. And again, it's a condition precedent. You can't get your motion set down unless the party has filed a statement of property, so that when the application is commenced, you're going to be doing the notice of motion, the affidavit, and the statement of property. It can't be left until later. It must be done at the very beginning. Now, some comments about the statement of property, because the form itself is not as clear as it might be. For example, under land on the first page, when it says estimated value free of encumbrances, it does not mean the fair market value subtracting the outstanding mortgages, and then that's the value free of encumbrances. Any logical person would assume that's what's meant by the form. It's not. What is meant by the form is that you should be putting down under the value of land the fair market value, what the party could sell the property for without taking into account the outstanding mortgages on it. So that if a client comes in and you see a form that talks about a house in Rosedale worth $30,000, you know that the client has not filled out the form correctly and has not put down the fair market value. So you should be alerted to that when you're typing the forms from the client's notes, to be thinking about the fair market value of the property. Because on the last page under debts is where you put down the outstanding mortgages, and that's on page 175. So that in order to determine what the person's net worth is, you take the value of the land less the mortgage listed on the last page. Now, page 172, you'll see household items and vehicles. And this is a very, very tricky thing to fill out, because most people haven't a clue what they could sell their household furniture for. And very often what they're putting down is replacement cost. So that you'll get a form back from a client of fairly modest means saying that the contents of their house is worth $45,000. Now, it may in fact cost that today to replace the things that they have in their house, but that's not what the form is looking for. What we're looking for is, what could you sell the contents of the home for? What would it fetch on the open market? So that generally speaking, you're going to be looking at significantly less than what it would cost to replace the property, or even what was paid for it 10, 15 years ago. So that again, that's something that you should be alerted to, and I'm sure many of you help the clients fill out these forms. They may call you with questions about how to fill them out, and you should be advising them that it's the fair market value, what you could sell this stuff for. Cars are a little bit easier. I think most people have a fairly vague idea of what they could sell a car for. Now, the other thing too to remember is that when the client is filling out this form, we're interested only in what his or her property is, not what the other spouse has, but what he or she has. So that if the family car is registered in the other party's name, it will not come on to your client's affidavit. It's only the property that he or she owns that comes onto the form. Under savings and pensions on page 173, it's not in the precedent. You may want to make a note. What I very often do is I will put down the actual balance in every bank account with little brackets underneath saying, as at January 29th, say. I'll have the client look in their bank book, read me out the balance and the date of that balance, because like all of us, their bank balances are going to fluctuate. And what we're trying to do on the form is to fix, at one point in time, what their financial circumstances are. So you may want to put in little brackets the date at which that's the accurate bank balance. RRSPs, again, another note that you may want to put on is that that's the gross value. As you probably are aware, if you try to collapse an RRSP, a registered retirement savings plan, you have to pay tax on the money that comes into your hands. So that if a plan is collapsed, its value is going to be less than simply the amount that's sitting in the hands of the trust company or the bank or whatever. So you may want to make a note again to make it perfectly clear that there is nothing taken off for tax. As far as the securities are concerned, usually you can simply look in the Globe and Mail, see what they're trading at that particular day, the stocks or whatever, and put down those values. The balance of the form, I think, is fairly straightforward except for business interests. And if the party has an interest in a private business, you'll know that it's going to be very difficult to value, and you're going to be dealing with quite a complicated case. Under debts, again, these are fairly straightforward, and you may also want to put in a date at which the debt is accurate. Now, another method by which you can commence an application for division of property is by way of a simple writ and statement of claim. And you'll find this precedent at page 191. Now, this particular precedent is really fairly all-encompassing. As you'll see at the top, it's a writ for custody, division of property, and support. And if you have a case in which it's that complicated that you're dealing with all kinds of different issues, you will probably want to proceed by way of writ and statement of claim, because then you have the opportunity of really controlling the lawsuit. If you have a complicated claim like that and you commence by way of originating notice, what will happen is that the judge will probably order a trial of an issue, which means that you then have to redo all of the documents, you have to set up a whole issue to be tried, and you waste a lot of time. So that if it's complicated, I find that it's much easier to simply start by way of written statement of claim and get on with it in the ordinary course. Now, family law is peculiar in that we have yet other choices of how to start these things. A claim for division of property can also be joined in a petition for divorce. And this you'll find at page 224. Which is a special page in the petition for divorce form in which you can join other causes of action. So that it's right there on that page that you plug in the claim for the division of property. Now, the last way that you can advance a claim for division of property is in a counter petition for divorce. In other words, the petitioning party may have simply claimed a divorce and nothing else, and you, as acting for the respondent, wish to advance a claim dealing with property. You can do that in a counter petition, and that you'll find on page 228. 226 is the beginning of the answer and counter petition, and the actual property claim you can see is set out on page 228 under the heading Property. Now, something to remember is that the provincial court family division, or family court as we usually call it, has no jurisdiction at all to deal with property matters. It's only the Unified Family Court, Supreme Court, and County Court. Now, other matters that are related to strictly division of property and compensation for property are the issues of exclusive possession. Generally, one party may be seeking to stay in the matrimonial home rather than having it sold and the proceeds divided. And one can often get a restraining order to prevent the parties from disposing of the property before the trial. And that's something that very often has to be done on an urgent basis, and sometimes is even done on an ex parte basis. Typically, the way one of these actions will proceed is husband and wife may separate, they may own a home and have a couple of children, and say the wife is at home with the children. The husband may want to have the property sold. He would apply, as in that very simple originating notice, for a declaration that the property is a family asset and for division of it. And the wife may then cross-apply for exclusive possession of the property, custody, and support. Now, a word about proceeding by notice of motion, because here the procedure again is peculiar to family law, and you'll find that family law tends to be fairly peculiar altogether. The Supreme Court Family Division changes the rules all the time. And it's always a good idea to check with the family law office to find out what the current mythology is, because they literally change it practically week to week. But essentially, if you're proceeding by way of a notice of motion, returnable in the Family Law Division, you go to Family Law Motions Court, so that the notice of motion will say, take notice that an application will be made to the Family Law Motions Court. Now, Family Law Motions Court is like weekly court, sort of, except that it's at 145 Queen Street West, and they're all similar. You know, the similarity is in name only. The lawyers do not gown. The clients attend the motion, unlike weekly court. Like weekly court, a record is required for all family law motions that go to Family Law Motions Court. And the record will be made up of, as always, the material that you'll be using on the motion, but also a special document called a Statement of Prior Legal Proceedings, which you can obtain from 145 Queen. And it simply sets out in a list form the date of the marriage, when the parties separated, and what kind of motions there have been before this one, and the outcome of each, so that the judge can look at the first page of the record and can skim through it and see what's going on. Now, if you're acting for the applicant in one of these motions and you're preparing the record and you've served the other side and they've not filed any material, you have to attach a letter to the record saying why there is no material from the respondent. It's absolute insanity, but you have to do it. Now, very often you will have no idea at all why the other side has not filed any material. And you can simply say that in the letter. The lawyer will type out, I have no idea why the other side has not filed material. Your boss will sign it, you paperclip it onto the record, and the motion can then be set down. Without that stupid letter, you can't get the motion set down. It makes no sense at all, but that's family law for you. Now, the motion itself is heard by the judge in his chambers, actually sitting in his office behind the desk. People are often smoking. He may be having a coffee. It's fairly relaxed. What happens is the lawyers go in first and discuss with the judge what the case is all about. The judge may then want the clients to come in and talk to them and see if the matter can be settled or if any portion of it can be settled. If it's not something that's capable of settlement at that point and seems like it's going to be complicated, the judge will very often order a trial of an issue and may in fact refer that trial to a family law commissioner. Again, a peculiarity of family law, there are these people called family law commissioners who are sort of like junior judges or a species of master, whose job it is to have hearings on issues like custody support and division of property. They make a report as to their findings and recommendations after the trial, and that report goes back to the referring judge, who will either confirm the report or do something different, so that what you have is a trial in front of the family law commissioner, which is conducted exactly like any other trial. And then you'll have an argument really in front of the referring judge as to whether or not what the family law commissioner did was right or not. And that's a peculiarity of family law. And commissioners are used a great deal in family law, because you can generally get a hearing before a family law commissioner much quicker than you can before a judge, so that it's a way to have a speedy trial in a way that's very often not available if you're simply on the regular list. Now, a word about maintenance and support, which is the second thing on my list, and I know it's 1 o'clock and I'll talk real fast. Jurisdiction for maintenance is found in the Divorce Act, which is federal jurisdiction. Support is under the Family Law Reform Act. And the difference between the two, other than the names, is that maintenance is what happens after the parties are divorced, and support is what happens while they're still husband and wife. The legal principles are exactly the same. It's a financial provision that's paid to a dependent spouse or child from the spouse who has the ability to pay. Basically, you're entitled to maintenance or support if you need it, and if the other party has the means to pay it. So that what you're looking at are means and needs, essentially. Now, again, when you're faced with either an application for maintenance or support, you've got another one of these terrible forms. Financial statements, which you'll find in the materials. On page 208, you'll find the statement of financial information of the applicant, wife. These forms are a colossal pain to fill out. Now, the reason, looking at page 209, the reason that the form is divided up into weekly, monthly, and yearly columns is so that a client can put down under the monthly column things that they pay for on a monthly basis, like the rent. In the weekly column, they will put down things that they pay for weekly, like food. And in the yearly column, they'll put down things like car insurance, house insurance, things of that nature that are paid for on a yearly basis. Tell the client when they're given the form they don't have to figure out everything on a weekly, monthly, and yearly basis. Very often you'll get the form back and they filled out every column on every line. That's not what it's designed for. Now you'll see that there are two similar pages on the form, 209 and 211. The first, 209, is for expenses, and what you're looking for there is the client's current expenses. What are they currently spending? Very often they'll be able to spend nothing because they have no money. Or they may not be able to give you any kind of an idea of their current expenses, because if it's the wife, the husband may in fact still be paying all of the expenses for the family, and she may not have any idea at all as to what her current expenses are. If that's the case, you simply say so. Over the page, on page 211, you'll see the proposed budget. And here is what the client thinks they're going to need to live on in the future for themselves and the children, depending on which party you're dealing with. Now, one of the things that I very often leave out of the proposed budget for both the husband and the wife is income tax. The reason for that is that when the parties finally have a court order that obliges the husband to pay support for the wife, or if they have a separation agreement that obliges the husband to pay support for the wife, the amount of support that he pays on a monthly basis is completely tax deductible to him, and it's income in the hands of the wife. So that at this stage of the game, you don't know what she's going to be receiving or what he's going to be paying, so you have no idea what their income tax situation is going to be. And I will very often leave it out with a little note saying unable to calculate. And it's a question of arithmetic once you can calculate a client's needs after tax to figure out what they're going to need on a gross basis in order to net that amount of tax. Other lawyers leave it in. It's a question of style. I find that it's easier to deal with without the income tax figure in there, because it's going to change. Whatever their current taxes are, in the proposed budget, it's going to be different depending on the amount of support that's paid. A little note to put at the back of your minds, things that are not on the form: cigarettes, liquor, car licenses, charitable donations, newspapers, magazines, books, records. These are things that you could put into other categories, but very often it's easier for a client to separate these things out specifically. And it's often helpful for the client if you can remind them of these things. There's nothing for pet care. The other thing is, if you're dealing with a client who has very young children, there's nothing on there for diapers or diaper service, which can be a considerable expense for a young parent. And those are the kinds of things that you can be doing a great service to the client if you can remind them of them. Again, with maintenance and support, we've got the same kind of jurisdiction. The Supreme Court, the County Court, the Unified Family Court. You can go by written statement of claim. You can go by originating notice. You can go in a divorce petition or in a counter petition, and you can go to the Provincial Court Family Division. And a quick word about their forms, because they're totally different. At 159, you'll see the Provincial Court Family Division forms. And as you can see, they're unlike anything that you normally work on in the office. You don't start off with a notice of motion. You start off with this strange document called a notice of court hearing, which you simply fill in the blanks. It's very straightforward. Over the page on 160 is the application, which sets out what the party's claim is. And as you can see, it's basically a shopping list, and you check off the things that the client is interested in getting. So that here you can see under little 1, I ask for an order for the following, and the first thing that's checked off is 1A, support. And then you've got a couple of little boxes down here, me and the following person, namely a child. So that's how these forms work, and they take a bit of getting used to if you've never done them before. On page 161, you'll see the particulars of the claim, or the grounds for the application, are set out. And here the lady's saying she's the best parent and she doesn't have any money, she's on welfare, and her husband can afford to pay support, which is basically all that you need in order to support the claim. And then she signs it down on the bottom. She must also do a financial statement, but naturally the forms in provincial court are different than the ones in Supreme Court, and you'll see a very different looking financial statement on page 163 that's peculiar to the family court. All of these documents are served upon the respondent together with blank forms for him to respond. He gets the financial statement, the notice of court hearing, and the application, together with a blank answer and a blank financial statement, so that he can fill it out and serve it and file it with the court. The advantage of provincial court is that very often you can get a hearing much quicker than you can in Supreme Court. They're quite streamlined, and depending on where you practice, if you practice out of Toronto, if you're from out of Toronto, you will find very often that your bosses will be going to family court more often than they do in Toronto. There are no precedents here for interim relief,